Good afternoon and welcome. Thank you for joining us for our October webinar. I want to give a little bit information about our organization first. And the organization that we work for is called Standpoint. Standpoint serves domestic violence, sexual violence, and trafficking survivors, advocates, attorneys, and other system professionals across the state of Minnesota. We have lawyers and advocates that provide support over the phone. We also provide legal advice, all free of charge. Our action line is open Monday to Fridays, 9 a.m. to 4 p.m. There is no question that's too big or too small because we do exist to be of service to all of you. So please call us. Today's topic is options for survivors with criminal records, criminal expungements. Presenting today are two of our very own staff, Amy Lauricella and Marie Banks. I will let them introduce themselves after I do some initial just logistic stuff with all of you. So first off, my name is Ty Cinnabon. I'm the Advocate Support Program Manager here at Standpoint, and the role I have today is just to facilitate the training. So if you have any questions, go ahead and type your questions in the chat box below, and I will let Amy and Marie know. And also, I will be sending the link to the PowerPoints and some other handouts for today's training in the chat box momentarily in a minute here. So please feel free to print out the PowerPoint or any of those handouts if it helps you to follow along better. Before I hand the mic over to Amy though, I want to give a quick reminder that today's webinar, like all of our other webinars, will be recorded and uploaded onto our YouTube channel, Standpoint MN. So if you have not subscribed to our channel, please do so to get notifications when we upload new videos. So that's all I have for now. Amy, you ready?
Oh, sorry, can you hear me now?
Yes.
Oh, perfect. Sorry, gang. Hi there. I'm Amy Palmer Lauricella. I am one of the staff attorneys here at Standpoint, and Marie and I will give another little brief overview of exactly what that means and what we do in just a minute here. But I am our attorney that provides legal advice to victims, survivors of sexual violence, domestic violence, and trafficking around the state on employment issues that might come up, not just if they are actually victimized in their employment or in the capacity of an employment situation, but if they're victimized outside of the workplace, what are their rights inside of the workplace so that they can stay safe, stay stabilized, and maintain that source of income. And then I also do a lot of our advice and counseling around civil aspects of the law and whether they have the right to sue the person who's harmed them, those sorts of things. So that is my background. Marie, you want to say a little bit about yourself?
Yeah, buenos dias everyone, bonjour. My name is Marie. I am the Underserved Populations Outreach Advocate. So I'm one of 5 advocates here at Standpoint, and a lot of what I do is engage with community and make sure that our accessibility and our resources are available to folks in community, especially those from multiply marginalized or oppressed groups. So I do a lot of work around systemic oppression, engaging in community, and increasing accessibility and understanding on the legal system for communities.
Great. And then the other areas that we also do legal advice and advocacy support around, we can do safety planning, resource referral, crisis intervention to folks. We have advocates, 6 advocates here, all of whom have a lot of different expertise in a variety of different legal areas. And then we have attorneys as well who can provide specialized advice with an understanding of what family law, for instance, has to do with a particular situation of violence. So just know we are free. We don't ask any questions about level of income, demographics. If we're asking questions, the only reason is just so that we can provide better tailored legal advice to somebody in advocacy services, not because it's necessary in order to obtain our services. So just keep that in mind. And at the end of the webinar, you'll see our contact information so that folks can get a hold of either Marie or me directly. Otherwise, you can always call our action line and you'll be routed to the right person. The other thing I want to point out too is on the right here in our Zoom webinar chat box, Ty has uploaded the Dropbox link to those resources that we're going to be using today. So feel free to click on that. You'll see the PowerPoint. There are also a couple of handouts that might help all of you as you're working with clients who might have criminal expungement needs. So please do check those out. Those will be available, save that link. You can access them at any time. And the other thing is, so this is a video, this is being recorded, but it is not a video recording today, which is a good thing because Marie and I are both in costume celebrating Halloween. And I don't know that you'd be taking us as seriously if you understood that we were a clown and Kelly Kapowski from Saved by the Bell. So, so yeah, hope you all are enjoying yourselves out there on this Halloween day, and we'll get started.
So when we're looking at objectives for today, we're going to be talking about a lot of different things, but mostly we're going to be talking about how the criminal justice tends to look at clients as criminals, and what sort of engagement that our clients as victims or those who are surviving abuse and experiencing abuse are navigating the criminal justice system, where they're seen, and how their cases are being handled. We're going to be discussing the ideal candidate for criminal expungement, some notable strategies on preparing and looking for expungements, and what kind of documentation you need. And we're also going to be talking about understanding the expungement process. So Amy's going to get into the weeds on the law and how it applies as a legal option for criminal expungement, and what that process is going to look like. And I'm going to be talking more on the dynamics of cases that we've seen, typical charges that we're seeing, and client stories, as well as safety planning. So as an advocate, what you should be doing to help your client prepare for an expungement and determine whether or not they're eligible for an expungement. We're also going to be offering some resources other than the handouts which are very helpful for folks to take with them as they do their work in advocacy with clients. We're also going to be providing some tips on finding resources in Minnesota that offer criminal expungement and education resources, as well as some alternative options for those who may not qualify, or who want more information on whether or not they qualify. So those are some of the objectives. And something to keep in mind, and this is honestly something that people do get mixed up quite a lot, so I wanted to make sure that we understand that criminal expungement is different from housing expungement. They're two entirely different processes, and honestly, it's probably going to have to be another webinar at some point. But for the sake of our time today, we're going to be focusing on criminal expungement. Did you want to say something, Amy?
No, that's great.
Oh, okay.
Keep going.
Okay. All righty. So when we're looking at clients who have criminal records, we should be looking at the lifelong impact of trauma and the process that it took for them to attain a criminal record, right? So a lot of our clients that we're working with are from communities or groups that are experiencing individual oppression and abuse, but mostly in a wider sense of the word, a systemic abuse. So a lot of these individuals that we are seeing accessing services that have criminal records are victims of both individual and systemic abuse and oppression. So we're looking at multiply marginalized folks, people of color, queer and LGBTQIA2S plus folks, and lower income, impoverished, or folks with mental illness or substance abuse are usually the ones that have pretty lengthy criminal history. And what we're doing when we're considering their trauma is we're looking at a few concepts. So we're looking at negative experiences. So a lot of these clients are going to have a upbringing or a family history where the people who brought them up and raising them also have criminal history. They might have either engaged in criminal activity, or they are incarcerated, or they have negative experiences with the criminal justice system. So already they have that environment in which they were brought up. And when we're talking about groups that are being oppressed systematically, like people of color, there's a lot of negative experiences that are common as a collective, a community. So in more impoverished areas, low income, you're going to be seeing a lot of criminal record and a lot high criminal crime rates, people with documentation. There's a lot more negative experiences coming from law enforcement interaction and engagement. So there's going to be tension with authority, and social services is usually coming from a place of bias when you're looking at communities of color. And there's a lot of neglect and lack of support from social services that we're seeing on folks' family history. We're also looking at a repeated experience of abuse and harassment that is experienced in the criminal justice system from both family members and folks in community that really paint a pessimistic and negative view and interaction because of the experiences of individuals and community and family for our clients. So there's a collection of negative experiences from a very young age in these folks that is already setting them up to have a very hostile and volatile perception and interaction with the criminal justice system. So when we're looking at those folks, a lot of the survival mechanisms are going to be considered as high risk for criminal activity and recidivism. So the survival mechanisms that these folks have to engage in as a result of their environment is often that of distrust, especially with systems professionals because of the negative experiences by family and community. They're going to be a lot more guarded and sometimes aggressive in the way that they communicate, or they're perceived as being aggressive in their communication and behavior when they're interacting with the court system, the criminal justice system, and social services. And they're going to be seen as high risk due to their participation in criminal activity. A lot of clients are at a very young age engaging in drug trafficking, drug selling, fights in school. You're going to be seeing a lot of gang involvement or a risk for gang involvement for these folks, and just overall engagement in activities that are at risk for receiving a criminal charge. And also, as another result, there's a lot of unhealthy relationship dynamics. So a lot of these clients that we have don't have modeling of healthy relationships in their family or their community as a result of both familial and systemic oppression. So there's not a whole lot of healthy relationship dynamics that they can receive. And as a result, there's a response system to the survival mechanisms and the negative experiences that's going to look like a loyalty to their abuser, a trafficker. Oftentimes, as we all know, that there is a love component, a loyalty component, a love for the person who's abusing them. It's often a family member or a romantic partner. We're going to see a lot of hostility and negative perspectives on systems because of a frequent interaction that is negative with the criminal justice, legal, or social service system. A lot of our clients get they get categorized as being uncooperative or ghosty. So a lot of our clients seem to vanish from time to time for weeks, months at a time, and then they come back. And there's not really a reason for it. Sometimes there is, sometimes there isn't, but a lot of the times folks who are surviving abuse do end up vanishing or dropping off the radar for a little bit. And that's why they're seen as uncooperative in the criminal justice system. And they're also unwilling to disclose or give accurate information on their self or their experience because of the distrust and the pessimistic view. And the experience that they have had with the criminal justice system. There's a lot of negativity towards that. So even if they are eligible for expungement, if they're unwilling to disclose their abuse and how it relates to their criminal activity, they are seen as uncooperative and ineligible for a lot of these legal remedies. And another response is that they're often resistant to treatment plans or court mandates. A lot of the times there are treatment plans that are too long or treatment plans that are not conducive to the environment that the person is living in, or the dynamics of their relationship prevents them from accomplishing those treatment plan goals. So that's another reason why they might be seen as uncooperative or ghosty.
Yeah, I think the other thing that's important to kind of put in a perspective here too is, that court mandate piece of it right there, Maria, that you're talking about. Sometimes this stuff results in fines. There's always that just capacity to pay the fine, which is a barrier on its own, oftentimes for this population. But, that sort of resistance to complying with that, because ultimately the reason that this is happening in the first place is because of all of this, both individual and systemic victimization. And the other piece that we are learning a lot more about is most of the clients that we eventually do talk with about criminal expungement have never really heard about it before. And we started to think about why that was. And I don't think it's because their public defenders are, purposefully leaving this information out or not preparing them for it. But I think it's more about the fact that because of what they've experienced, both as that, that negative perspective on systems and how that impacts what and how they engage with their public defender on, this information is just not ever being shared. And so it's not like, despite the fact that they were a victim, the court decided to convict them anyway. A lot of the time it's just completely left out of the process entirely. And so they're not getting adequate advice right off the bat about how to set themselves up for success in the criminal expungement process. So just some of those dynamics to keep in mind.
Mm-hmm. Thank you. So when we're looking at some common themes and some patterns that we're noticing in our clients who are surviving abuse are that they're oftentimes there's some form of exploitation. So whether it be survival sex, either that is forced upon a client to engage in survival sex for the resources and to support the abuser. Sometimes it is withholding financial resources from the person so that they have to engage in survival sex to sustain the family. A lot of the times they will be coerced or forced into drug charges. So either trafficking, selling, assisting in transportation. The victim is oftentimes the mule, for lack of a better word, when it comes to drug transactions. There is multiple levels of financial coercion and exploitation that are happening with these folks. A lot of the time, someone's credit line will be used, their state benefits, their county and state benefits. Something that I noticed a lot in our clients is that MFib or emergency assistance is often used and coerced so that they can't access it again, because with emergency assistance, you only get it once a year. MFib, you get it once for a period of 6 months, I believe. So sometimes survivors have access to county and state benefits or financial resources that the person who is inflicting abuse does not have. So we're seeing a lot of those kinds of charges, benefits fraud, tax fraud, forging checks, forgery, credit card fraud. Another one that we see is housing. So folks who are taking advantage of Section 8 or HUD housing, who are living with somebody and then causing them to be evicted and denied programming assistance. Some people we see mortgage. So someone, again, with who doesn't have a credit score where it needs to be, and the person surviving abuse does have the credit score. We're seeing a lot of forced signing of mortgages, home loans, things of that sort. Car loans, auto loans is not housing, but that's another example. For folks with citizenship status, we're seeing a lot of exploitation around that and threatening of getting someone deported or reporting them when they have an application in to get citizenship status or work visas. There's a lot of manipulation around status. And another form of exploitation that we're also seeing is prescriptions and medications for folks who have either a mental health diagnosis or they're taking pain medication for chronic illness or temporary disability. There's a lot of abuse and exploitation around prescription medications that we're seeing, especially for folks who are red flagged in the medical system for being abusive or misusing medication. They'll oftentimes be flagged. So those folks will use their victims to gain access to those types of medications. And as a consequence of exploitation, we're seeing a lot of folks being evicted from their housing. We get a lot of phone calls on housing eviction, which again, that's another webinar, but it is something that we see due to exploitation. So there's in turn, there's a lot of homelessness, right? There's a lot of folks who are homeless, they've been evicted, they have evictions on their records, their credit isn't where it needs to be, so they're having trouble finding affordable housing again. So there's a lot of homelessness around those folks. There's limited resources for legal representation, especially when it comes to criminal defense. So once someone calls our line and says that they have a criminal charge against them, even if they're a victim, it's really difficult for us to provide referrals for those folks because for whatever reason, it's just a part of our system that needs to probably change soon to accommodate victims. There's just no real affordable services for criminal defense, especially even with victims. Another consequence of exploitation is we're seeing crowded Menses reports. So when folks try to apply for jobs or they try to get housing, even if they try to sign up for certain classes, let's say for higher level education. So if you want to be a nurse or a mental health professional and they do a background check on Menses report and you have that crowded history, it's not going to work in your favor. They're viewed as quite unfavorable, and it actually deters people from wanting to rent to you. It deters people from wanting to accept you into their educational program and to sign up for classes. It's an intimidating deterrent the more charges you have on your Menses report, even though I'm sure we all do have Menses. It's just the more you have on there, the less favorable you're seen, regardless of the context of the charge. And because of all that, a lot of our clients are seen as problematic or high risk in courts and social services. So obviously the dynamics of abuse are extremely complex, and a lot of the times, like I said before in the previous slide, because of trauma, there's an unwillingness and a distrust in disclosing how abuse has tied into criminal charges and someone's criminal history. So if there's no disclosure and explanation on why those charges exist, they just know that they exist, social services and systems professionals, especially in the courts, are going to see that as a high risk or a problematic individual, right? And as a result of not being able to get a job because of their record, or to get housing, or to get into shelter, or to get into an education program, we're seeing a lot of returning to abuse because of the exploitation that they've experienced. So a lot of the times, like I mentioned before, let's say someone applied for emergency assistance with their abusive partner, and the partner they got accepted and they used it up, and now they're homeless and they need that emergency assistance for a down payment for an apartment. They no longer can have that resource. And same thing with MFib. If they are a parent and they have children, they're entitled to certain programs, but if they use it up, it doesn't present itself as an option again. And we're seeing a lot of that with transitional supportive housing programs. So if you have too many instances on your record, it really affects your ability to become eligible for supportive housing programs in the future. There's an inability to support themselves or their children. We're talking a lot about credit history and how important it is for someone to establish credit. But if someone's being exploited financially, or they have credit card fraud on their record or forgery, it's going to be hard for those folks to get access to financial support so that they can become sustainable and independent from their abuser. And like Amy mentioned before, a lot of these folks are not even aware of their legal remedy or the concept of expungement. That information is seldom provided to these folks. So by the time they get to us, they don't even realize that it's even an option if they've had to either stay with their abuser, or if they've had to try and navigate the system with all of these charges without realizing that there are options for them. And obviously the goal here is to make it seem like they have to rely on their abuser or their trafficker because of the exploitation, because of the consequences, because of how they're seen and perceived in systems. They don't feel like they can leave and sustain themselves. So it looks like we're going to do a poll. And this is just helpful for us to gain a sense of who we're speaking with. And we do value your input and what y'all have to say and what you see, because we're not the only action line and we are not the only direct service provider. So I'm sure there are stories that folks can share. And if you do, please, miigwech, please, ahead of time, thank you, share with us. So I don't know how we want to do this.
I just did this, Marie. So I started the poll. So I launched it already.
Oh, okay.
What I would like attendees to do, because you should be seeing the question, is answer it yes or no. And both looks like people are answering already. When I see that, can you see, Marie, that people are answering?
We can see the poll, but we don't see responses until I think you close it.
Okay. When I end it, you guys will see the response. Okay. And this is nice because it tells me that 9 people have already answered of the 12 that is here. So we're still waiting on 3 others to answer.
And it's also okay if we just want to move
So
forward.
I'm going to go ahead and end it now. And I'm going to share the results. And what the results say is 78% have worked with clients with criminal records, and 67% say that the records are connected to the abuse they are experiencing.
Yeah, wow. I mean, and this is what we've been finding too as we start having these conversations with folks that are calling us is, you know, and they may not necessarily even be calling us for their criminal record, but instead to ask about some other process. And it's actually more common than I think a lot of us expect to see that not only do they have the criminal record, but that their criminal record is directly connected to abuse. So that's really helpful context. And I'm I guess it just kind of reassures and reaffirms what we already know here, is that this is a problem that's, happening across the state. And I'm glad that you all are here to talk with us about it today.
Mm-hmm.
Yeah, because what we know is, and this is a national statistic as well as a statewide statistic, 1 in 4, that's 25% of the folks in Minnesota do have some level of a criminal record. And I think something that's really important to point out here, especially as the folks who are working with individuals, is, all of us, it is literally impossible to exist in this world and not have ever been in violation of some state or municipal code, right? State law or municipal code. But it is just who's getting caught for it, and ultimately what is happening to those individuals who are getting caught for it. And so this website that I've included down here on the bottom, the weareallcriminals.org, it actually was started by somebody who is from Minnesota, has worked at the University of Minnesota in a lot of different capacities too, and also just around the state. And it's just a place where folks share their stories to try to help everybody understand and get some perspective around not only just criminalization generally, but also why this criminalization of certain conduct in certain populations is what we're focusing on, instead of all of us committing these kinds of acts, doing these sorts of things, whether it's related to drug use or, not signaling when they change lanes on the road, right? Like, these are all things that are violations of our code, but we have a tendency, as at least our criminal justice system has a tendency, and a lot of other factors go into that, to over-criminalize certain populations. So we just put that out there as sort of some context, but I'm curious if anybody here on the webinar is interested in sharing a situation where their client did have a criminal record and how that was impacting their life. Obviously, please don't include any identifying details, but if anybody's interested, please feel free to just chat into that Zoom webinar chat box and let us know, and we'd be happy to read it out. Because I think it's important to think about what this looks like in real life, right? You just heard from Murray about this cycle and how folks get caught up in it, and how it sort of is this self-fulfilling prophecy, not self-fulfilling, but fulfilling prophecy, where oftentimes from birth, from a very, very young age, you are just caught up in poverty, oppression, really, a lot of criminal justice oversight, those sorts of things, and how that continues to impact. But it's also helpful to hear from all of you around the state and the things that you're seeing. Ty, has anyone responded?
Yes. So there's a comment here that says the client was arrested for an assault when their abuser showed up to their home in violation of a restraining order.
Mm-hmm. Yeah, I mean, I would imagine that anybody who's been doing advocacy work for more than 6 months has probably seen some level of that, right? Where because of either biases in responding officers or the way that our client is attempting to protect themselves, oftentimes it can look like the person who's harming them is actually the victim, right? And so there's a lot of situations where, and in particular, if they identify as a marginalized or underserved population, where that can snowball, and it can result in criminal charges that really have a very, very negative impact on that person's life, and might ultimately be a driving force to why that person ends up having to stay with the person harming them.
Mm-hmm. And we do see that a lot, especially in populations who don't have a good relationship with law enforcement or the criminal justice system as a whole, because we are seeing those individuals in community in kill or be killed in some situations where they do have to defend themselves. And abusers are getting to the point where they are manipulating the situation, and they're really good at taking advantage of the criminal justice system and using it against the person who is surviving abuse. So we get a lot of phone calls from clients who say, I have never called the police. The police have never been called on us. There's no police reports. There's no court actions. There's nothing. I don't want to get involved in any sense of the word. And one day and a situation happens and the victim has to defend themselves, and the abuser decides that they want to call the police and make a police report, and they want to file for an emergency order for protection, and that's the first engagement with the court system that those two folks have, right? So the court is going to see that there's never been a police report made, there's never any footprints or documentation on the abuse that's been happening, let's say, for years. And the first time that they have those two in the court system is because the abuser filed for an order for protection first. And that does, in many circumstances, give them the upper hand. And we do see people navigating and utilizing the criminal justice system and the civil system and the family court system to manipulate the situation and make the victim who is surviving abuse seem like the perpetrator. And a lot of that has to do with the values of a community who are experiencing a lot of systemic oppression and their unwillingness and their fear against filing police reports and engaging with the court system. We're also seeing a lack of information and education in the court system to assess for who's perpetrating abuse and who's surviving abuse. And you know, sometimes it just is a matter of there's not enough information, there's not enough documentation to make that assessment, but also it is due to a lack of training and awareness with systems professionals and the definition of criminal as it pertains to a domestic violence victim. We're working with a lot of legal terminology and legal definition of what is a criminal, what is a domestic violence victim. But us as advocates, we obviously know and see that it's not always clear, and you have to have a certain lens and a certain understanding on someone's environment and someone's upbringing and someone's position as an individual experiencing abuse and what that might look like, so that you are making a well-informed decision. But unfortunately, we're seeing a lot of folks who are accumulating different types of charges, and they're considered uncooperative, and they have a history. So it's just really an unfortunate situation at that time and at that point.
Yeah, I oftentimes, when I talk with attorneys who are looking at this issue, they'll say, well, you know, why did they plead guilty, right? Like, why did they do X, Y, and Z that ultimately resulted in this charge in the first place?
Mm-hmm.
And, you know, one client I worked with in particular sticks out here as just a really helpful example. Is she was being harmed by her partner. She was expected to sell drugs and, you know, provide the money that she earned from that to her partner. They also had a kid together. And so she got picked up on a drug charge. It was the fastest way for her to get home and protect her kid was to plead guilty. Mm-hmm. And to then get home, make sure that child was okay, child was safe, because that was also part of the abuse that she was experiencing, was that, you know, threat to children. And that was how her partner was controlling her. So it's easy to see why these charges happen in the first place, too, especially when a client is surviving and experiencing abuse and has that history of abuse and trauma.
Mm-hmm.
Okay, we're getting into the nitty-gritty here. So what exactly is criminal expungement? Ultimately what this is, so it doesn't, you know, make records entirely disappear. They don't go away in that sense, but it's the process of asking a court through the judge to seal records of a criminal case. And what I mean by records is, you know, records any step along the way. At every point in our criminal justice system, anytime you're interacting with it, there is some record created from that very first potentially 911 call, or that very first patrol officer coming by, all the way through to arrest, through to some level of incarceration, pre-trial, sentencing, the trial itself, conviction if that's what happens, execution of that sentence too, right? There's a whole plethora of records that are created at a lot of different agencies. And so what criminal expungement through the Minnesota court system does is it seals those in all of those agencies, and it seals them away from the public. So they wouldn't be able to be seen by, let's say, a landlord who's running a background check and trying to vet a potential tenant, or an employer who's running a background check and trying to figure out what that person has in terms of a criminal record. Now, it doesn't destroy them. There are agencies that still retain those records. Like I said, they're just sealed. And so there could be situations where they need to be unsealed for certain reasons. And there's an example here where the Department of Human Services, they still can see some of those things in somebody's criminal history when they're applying for a job that requires a certain level of clearance or background check. But they are still hidden from the general public, right? And, you know, like if you're applying for a job at a law enforcement agency, they also will have access to those records, even if you are granted a criminal expungement.
Mm-hmm.
So I think generally people understand, you know, what the benefit is. The benefit is you hopefully can go about your life in and be able to access stable housing, be able to access stable employment if you are granted an expungement and your records are sealed and kept away from the public eye. So that is at least what the criminal process or the criminal expungement process generally is designed to do for anybody who applies for this, right? They are restored to that legal status that they had before they picked up that criminal case. The thing that we have recently been finding is there is a specific piece of our statute so I'm not going to get too legal with all of you today because it's you don't need it, but there's a specific subdivision in our criminal expungement statute that directly deals with what happens when the underlying crime has a nexus to the victimization that a person was experiencing, right? That person's status as a victim. And it's actually a stronger expungement remedy if people are able to actually make the argument when they're petitioning for criminal expungement that it was that they were a crime victim at the time, and this is why it happened. So ultimately, it does the same kind of thing where it restores you to that same legal status that you had prior to the arrest or prior to the indictment or whatever ends up happening. But it also means that you could never be, accused of giving false information by not acknowledging that an arrest, indictment, trial, etc., ever happened in the first place. So it kind of, in terms of how the person has to communicate about what happened in future job opportunities, future housing opportunities, those sorts of things, it allows you to basically act as if it never occurred in the first place. And because there is this specific language in the statute, it makes it very clear if you can make that connection, that nexus be understood by the judge. The fact that this is explicitly carved out should hopefully give our clients, I mean, the idea was that it would give our clients a leg up in actually being successful in these expungement petitions. But the challenge that we've been finding now as we've started looking at this over the past year or two is nobody's using this. And ultimately, while we could talk all day about some ways that we might be able to make our statute stronger or, changing some of the procedures or processes to getting expungement to happen in the first place, ultimately, it's a total lack of awareness. I think it's a lack of awareness, even with the attorneys that are actually doing these kinds of cases. Oftentimes they're not asking questions around the victimization nexus. And so they're not even getting that information from their clients, and they're just moving forward with expungement petitions with just the normal sort of generalized information about, yes, I've been rehabilitated since I committed that crime. It is impacting me negatively in this way. They may never actually elicit the information necessary to establish that nexus, which makes it that much, should, in theory, make it that much easier for an expungement to be successful. So we're doing a lot more just footwork with folks that are taking these cases on a volunteer basis. As folks are finding out more information about this, connecting with court information and the folks that are actually assisting in some of that petition drafting at the courthouses, those sorts of things. Those can be really good opportunities for advocacy to also get involved and just do a little bit of education, because people, you know, despite the fact that this is written in the exact same statute, folks just don't seem to know it exists. So again, you are not going to be expected to make these types of, you know, providing this kind of legal advice of yes, you qualify or no, you don't qualify as you're working with your clients. So just off the bat, know that that's not what the slide is for. What we wanted to do with this is just more so to make you all aware of the kinds of things that can qualify for expungement. And then, you know, to the extent you have a client that you're working with who may qualify, have them call us. We're happy to vet them and, you know, actually dig into their records, look at exactly when they're, let's say they were on probation, when did that probation period end, what level of crime are we talking about, and then how much time do they have to stay, quote unquote, off paper, meaning they don't have any new charges, they don't have any new terms of release or conditions of parole or probation until before they can apply, because we don't want folks just going into a court and applying before they're eligible, because it'll just take that much more time to get there. But ultimately, if you're working with a client where criminal charges were dismissed or they were found not guilty, or for whatever reason it did not result in a conviction, those folks qualify for an expungement. If they were a juvenile prosecuted as an adult, that can qualify. If it's certain controlled substance violations, but that were dismissed or discharged, you know, sometimes that might look like a certain kind of discharge, that would qualify. Terms of any kind of diversion program or a stay of adjudication, so long as they don't get any new crime, pick up any new crime charges for a 1 year afterwards, they're eligible. The thing that we want you all to kind of think about and understand is, like, what we're looking at is, if it's a misdemeanor, you got 2 years. If it's a misdemeanor or petty misdemeanor. If it's a gross misdemeanor, you're looking at 4 years. If it's a felony, a nonviolent felony, it is typically, you need at least 5 years where you're not convicted of a new crime from that point. And, you know, we have the list in the citation to the statute where you can see exactly what qualifies for expungement and what doesn't. But again, if you have questions, if you think somebody might qualify, if you're not sure and you don't want to provide misinformation, which we totally understand, that's what we're here for. And we're happy to walk through that with either the client or with you.
Mm-hmm. And I will say that the statutes, that link is really helpful, because it is a very hefty list of charges. So, and they're very specific. So even if you wanted to even take a look at that list and then call us, and so that we know exactly what charge you're talking about, that link is really helpful.
Yeah, and the other thing that I would just want to point out here too, so, you know, this first bullet here on that slide, if it was dismissed or they were found not guilty, you know, that doesn't mean that these records go away. You can still see that there was a not guilty or a dismissal if you were to go into Menses, or if you were to go and look at BCA records. And so those sorts of entries can still negatively impact somebody, because an employer might say, I don't want to risk it. I'm not gonna hire this person because they have this arrest on their record, or they had this ultimate adjudication, but it was after 180 days of jail time, and that seems weird to me, and so, you know, I don't want to do it. So it's that kind of stuff where getting those records sealed is still going to be a huge benefit to clients.
Amy.
Oh, sorry.
Okay, there's just a quick question, and I might be relevant to what you're talking about now, but the question is, was it being expunged if there wasn't a conviction? I was of the understanding it was the conviction which is being expunged.
Right, that's what I was just saying, is there are still records connected to that charge. There's still records connected to the dismissal, and so those are the things that can get sealed.
Mm-hmm. And in that situation, it depends on the client and what they want to do, but a lot of the times it can be helpful to be proactive about that, knowing that that information will still be on your Menses report. A lot of the times institutions, individuals, systems professionals will only see the charge and they won't see that it was dismissed or sealed. So a lot of the times as a part of safety planning, it might be helpful to print it out in detail so that if you apply for a job or if you apply for housing and it's a charge that you feel like is going to deter the person from accepting your application to something, you can list, yes, I was charged for this, but it was sealed, or it was dismissed, I was found not guilty, and then provide that explanation for them and be proactive with that so that it doesn't look like you're trying to hide the charge. Because I've had clients who have had cases where it was either reduced or dismissed, but it does take a long time for the court system to update that information in Menses. So what happened was the client tried to apply for housing and the case wasn't listed as dismissed yet in Menses, and they were denied for housing even though it had been dismissed and it had a status of dismissal, but the client could not provide the explanation or the paperwork that was needed to prove that. So as a part of safety planning, yes, it will still come up on Menses, but sometimes in certain situations, it is helpful for the person to be proactive and to be forthcoming with that information and provide as much detail as possible so that they don't seem like they are simply just waiting for the person to discover the crime and to have, hopefully they have trust in the person to notice that the case had been dismissed or them found not guilty. Because a lot of, let's say, landlords don't even consider that. They just see the charge and they want to discredit or avoid that potential risk.
Mm-hmm. Absolutely. And just something else to think about too in this situation, Marie, that you're talking about is you don't have to wait at all. There is no time period that you have to wait if ultimately it was resolved in your favor in terms of the dismissal or being found not guilty. So just keep that in mind and let your clients know that this is something they can and possibly should do right away.
Mm-hmm.
So just to sort of give you, we're not going to run through that whole list that Marie was talking about where that link goes to. I think it's something like 25 different charges, but just know that most of the felonies that do qualify for expungement are either drug, fraud, or theft related felonies. So those do not include violent felony crimes if that's ultimately what was adjudicated as the crime. So for instance, with our panelist or our attendee who wrote in about the client who was arrested for an assault when it was actually their abuser who was showing up at their home in violation of a restraining order. If what that client was then charged with was, maybe they were charged with felony level assault, if it wasn't downgraded to a gross misdemeanor or a misdemeanor at any point in time before it was ultimately determined what it was, either through a guilty plea or through a conviction, that will not qualify for expungement. We do a lot of counseling with folks around this, and ultimately it's a really, really hard thing to have to talk to somebody about, because oftentimes, in particular, if they get connected with that felony level violent crime and it's not downgraded before a plea or before a conviction, there's just nothing that we really can do in terms of expungement. And we'll talk a little more later. Maria will run through a couple of strategies that you can use with folks who may have criminal records that are just not going to go away. The other thing I think, real fast, Maria, is just to point out for those that are kind of interested in what does this mean for when folks are on, predatory offender lists and registrations. Those are convictions that cannot ever be expunged. So if somebody has to register as a sex offender, that's not going away either. So here, in terms of just what you want to see in terms of the folks who might be an ideal candidate for expungement, is you need to be able to show that your criminal record is somehow preventing you from attaining an otherwise sort of expected thing in society. I have to believe that this is not actually that hard to show, so long as you actually can articulate it well in your petition. But most of the time, if you have a criminal record, it does make it hard to get a job. It really does make it hard to get housing, or if you need a professional license for something. These are just sort of the typical things that we see. But But just make sure as you're talking with folks about this that they're really clear in their petitions that this is negatively impacting their life significantly. We have seen situations where clients may not necessarily put enough information into their petitions, and judges will deny the expungement on the basis of need. I don't believe that this criminal record is actually negatively impacting you to such an extent. Wait a year, and then, you know, if it ends up being harder for you, then come back and explain to me why. That kind of messaging and that kind of outcome for a client can be catastrophic, because obviously the reason that they're going through this in the first place is because they need this to go away. It's not like well, my reputation is at stake, right? If people are going to the court to try to get these records sealed, it's because they're already really struggling. And then to be told by a judge that you need to wait a certain amount of time longer and you need to be even more harmed by this record can just be a huge barrier to ever having them come back. So just kind of walking through that with your clients can be really helpful. So just focusing on that. And then Marie, do you want to talk a little bit about, you know, the open cases, warrants, fines piece of it? I know a lot of our clients end up actually having a lot of that.
Yeah, that definitely is a thing. A lot of people have active warrants that may be directly tied to the abuse or may be indirectly tied, but whatever the case is, if it's an active warrant that someone is aware of, then it would probably be in their best interest to look at getting it quashed if possible. There is a warrant hotline, at least for Hennepin County, and I can't speak on the other counties, but there is a warrant hotline that could be part of safety planning to see, because sometimes clients are unaware that they have a warrant, and this is very possible. I saw this a lot in the shelter, that clients were unaware of any active warrants that they might have. So active warrants are risky because A, you can't get anything expunged, period, and B, if you are looking at getting an OFP, any legal remedy, any an HRO, anything that is interacting with the court system, you're at risk of being arrested for your warrant. So in Hennepin County, they did provide a hotline that from what I understand is a confidential hotline. It might require some investigation from the advocate just to make sure it's safe. But it is a warrant hotline that you can call to see if you have any active warrants and to see if it is an option to get them quashed or what you need to do for them. So my phone's dead, so I don't have access to that number. But if you want, I was gonna read it out loud, and then I realized my phone was dead. So I will, if you are interested in that hotline, if you do any advocacy in Hennepin County and you haven't heard of that hotline, just send me an email or a message, Ty, and I'll make sure to get that number out once I charge my friggin' phone.
And then the only other thing that I wanted to point out here, and it looks like, sorry, our bullet points got a little messed up. The other thing that you have to show as a candidate for expungement, just generally, anybody who has a criminal record and wants to get it expunged, is that you have somehow worked to rehabilitate yourself and you know, rebuild your life afterwards. You have to show not only that you need it, but also that you deserve it, right? And so, you know, just talking with clients a little bit about what that means and how to talk about it can be helpful. And in particular, when we're talking about clients whose crimes are connected to their status as a victim and the work that we're doing with them, preparing them too for how hard that might be to have to talk about it and why they deserve it. So the piece here that I just wanted to stress, and this is something that right now we don't have up on our website, but hopefully within the next month or two, we will have this resource. So when judges are considering whether to expunge something or not, they look at the underlying circumstances of the crime. And so they're going to look at, why did it occur in the first place? How have you worked to change that so it won't happen again? And then why do you need it, right? If the client that you're working with has a criminal charge that's related to trafficking, domestic violence, sexual violence, that sort of thing, those are really important things for a judge to know, because of that piece of the statute where there's an explicit carve out that says this should be happening for victims of crimes, and they then, you know, are able to be returned to their status prior to that crime. So for instance, you know, you might talk to your clients about how comfortable they are disclosing that they have left the person who is harming them and who is either controlling them or threatening them or coercing them into committing crimes. The one thing that, you know, and you'll see in this resource that we eventually put out shortly, is we have to walk a fine line with our clients of talking about why it happened and how they were being forced into it, but also talking about they still have some responsibility in it. You know, you have to walk that line. Judges don't want to see somebody just shirking responsibility entirely because it seems to them that they're just making excuses, right? Like, we have to be careful with our clients that it doesn't come off as them just saying, no, this wasn't me. I didn't have any responsibility. It's because of this person in my life, which we understand is the actual situation. Those are the dynamics. But when we talk about it to a judge who may not be as well versed in the dynamics of intimate partner violence, those of trafficking, that sort of thing, we have to just help our clients to articulate and be clear that, yes, this occurred because of either the relationship they were in or the fact that they needed housing or they were being controlled or engaging in survival sex, but they also recognize that that was not an okay thing to do. And so what they did then is left that person, attempted to find stable housing separate and apart from that person, right? You know, those sorts of things. And then I also just want to put a note in here too. It can be helpful sometimes for victims not to disclose exactly what services were received, but it sometimes can be helpful for them to say that they worked with a victim services program to rehabilitate themselves and to stabilize their lives. Because in our statute, there's actually a prong or a carve out in there where judges can actually ask for a sworn statement from an advocacy organization saying that they worked with that person. And that can be used as evidence in support of why this criminal expungement should move forward and be successful.
Mm-hmm. And some shelters, at least the one that I worked at, we do have rudimentary treatment plans. So it will have a really nice outline of the individual's goals when they're coming into the shelter. And if you can show that they're utilizing programming, if they're attending classes, if they're engaging in community events, if they're taking advantage of the resources that the shelters offer, it can be a good way to get them thinking about the types of ways that they're stabilizing themselves while they're in shelter without necessarily explaining that they're in a domestic violence shelter. So you could either, if you have notes on a treatment plan that's been established in shelter, or if you have a treatment plan from let's say a CPS or IGWA case or sobriety. So a lot of folks coming out of treatment will have just really rough goals and objectives for their plans that you could utilize to help someone jog their memory and to organize themselves in preparing an explanation to the judge on how they've tried to stabilize themselves if they're having trouble coming up with those ideas.
Yeah, and then the other piece so we will be putting out a technical assistance packet that's written. It's geared towards advocacy. It's not for attorneys to be using it, and you know, it's for advocates and for victim survivors themselves to kind of look at to help prompt some of that language, because it can be hard when you're just looking at a blank form, especially a very detailed court form that just has a couple of lines to figure out what to say. But just know that in the rehabilitation statement, this is absolutely a spot where you're going to want to put that information that Murray just mentioned, and then also how they work to remove themselves from that abusive person, whether it was their trafficker or spouse or whomever. You're still going to want to include some kind of description of the client's responsibility and role in the offense, which that's where, you know, you have to work a little bit to thread that needle. We're always happy to help brainstorm and to, you know, kick around ideas. If folks are struggling with that, please do feel free to call us and we can kind of discuss how to best frame it. But yeah, really include it right there in that it's section 13 of the form. And then there's another section where in section 16, they just ask for any mitigating factors. And I would actually explicitly write out the statute, because there are a lot of judges that don't know that the subdivision 6A having to do with crime victimization, that nexus exists. So I would actually put in there in section 16 that 609A.03 subdivision 6A says, because of this nexus between my status as a crime victim and the crime that I ultimately was convicted of, that is a mitigating factor. You're not making excuses for the conduct, but you're simply including more information that the judge is going to want to consider when determining whether expungement is appropriate. Okay, we're getting close, gang. We're almost done. We just want to give you kind of a brief overview of what the process is so that you can help prepare your clients too, because unfortunately, this is not a short process. It's going to depend a little bit too on what county you're expunging records in. Some courts, like in Hennepin County, they actually have specific judges that have an expungement, a criminal expungement calendar. So they're going to be far more versed in these things, but there also is going to be probably a longer wait to get hearings. Whereas if you are filing in a county that probably doesn't ever see expungement petitions, maybe once a year, that's going to look very different. But just to give you kind of a general sense of what goes into this, there is a whole set of court forms that you can download, and we've got links at the end of this presentation to get you where you need to go. You got to complete all of those court forms. Once the petition and all of the forms are completed, you have to send a copy to all agencies that have records of that case. And so there are going to be some automatic ones, like the Bureau of Criminal Apprehension is going to be one. Whatever the court is that ultimately adjudicated it, whatever county court is involved, any of the law enforcement agencies are going to be in there. If there were any other government agencies, maybe it had to do something with firearms, right? Like there are going to be potentially, up to like 15 different agencies that you have to quote unquote serve. What that means in the context of criminal expungement is just mailing them copies of the form. And in some of the courts, you actually can serve them too. Just go into the information or the help desk, and they can work with a client on doing that. And then once you have sent all of those copies of the forms off, you also then file that paperwork with the court and request a hearing date. Something to keep in mind, and I can say with certainty, I've only worked with one client who has had only one charge that they are looking to expunge. Most of the clients that I've worked with have multiple, like many, many, many charges or convictions that they are looking to get expunged. You need to have a separate petition for every single charge. So this can be a very significant undertaking for somebody who might have multiple charges, and in particular for somebody who has multiple charges in multiple counties. So if that is what's going on with some of your clients, do please feel free to pass on our number, and we can talk with them a little bit about what that might look like. Maybe prioritizing certain charges over something else, because maybe there's one charge that ends up being the big problem charge, and then the other ones are kind of, no one seems to care about them. So we can talk with folks about what that actually means and how to strategize. So in order to complete those forms, just kind of a little very brief overview, and we provided some handouts too in that Dropbox link that Ty shared earlier that'll help. You don't have to memorize all of this. You don't have to write this down frantically. We have checklists that we've created because it's a lot, and it's a lot for you all, and it's a lot for your clients. You need a full criminal history to prepare an expungement petition, at least in terms of trying to get as much information as you can about all of the various ways that folks have interacted with the criminal justice system before going into court and saying, let's close this out. So you need to get courthouse records of all of the criminal cases. You can get that from the public computer in the courthouse. You don't have to have them printed out because that can cost money. If they have access to a phone with a camera, you can just have them take pictures. We do that a lot, where clients will, just send us whatever photos it is that they have taken. Just make sure that they take a clear photo of every page of those search results, right, that list all the different charges. Make sure that all of those cases and case numbers can be seen in the photo. And then that allows, maybe they're going to go to a clinic and they're going to get some advice from an attorney. That allows the attorney to then make sure that they're not missing something because they clearly know all of the cases and case numbers associated with this person. The other thing that they should also do is get their Bureau of Criminal Apprehension records too. And that does, there's no way around this, that does cost $8 to get a copy of the record. You can either go in person to the BCA, or you can request you can send a notarized request by mail and just enclose a check and a return envelope. Really important though, if your client does have any outstanding arrest warrants, if they go to the BCA to request their records, they could be arrested there. So just things to keep in mind as you're helping them navigate this. It might be better for that client to send a notarized written request and just know that it's going to take some time to get it back, typically a week or two, rather than just go in person and getting it the same day.
Mm-hmm.
So, real fast. So not only do you need your criminal records in Minnesota, but you also need your criminal records in another state too, if they do have them, because those are going to get pulled up and a judge is going to ask about them, and it is worth front loading it and being prepared. And then also working with those clients, because this can be really challenging, especially for folks who've experienced homelessness or may have been staying in shelter, trying to make a complete list of all of the home addresses from that very first criminal arrest or charge all the way up to and including your current address. So there's a lot of work that goes into these and a lot of work that gets done on the front end. But ultimately, if you can give your client some of those handouts that we have prepared and put online here in our Dropbox, that might at least get them started in terms of collecting it and make it a little more manageable. So it's a far more attainable process than just thinking, oh my gosh, I have to get all of this stuff and I have no idea how to do it and when am I going to do it and all of that.
Mm-hmm. And this is just a quick visual of the process. So once you complete those forms, you submit it. The court's going to ask, the judge is going to want to see statements and recommendations from agencies that have records relating to the case. The judge is going to review their statements and your testimony or the client's testimony, and the judge will make a decision based off those. It does take at least 6 to 8 months to complete, so make sure that you're telling your client and making them aware of the timeline, because sometimes people think that it's a quick and easy process, or they might not even have an idea of how long something's going to take. So that 6 to 8 months is a minimum process time that you should mention to them.
Yeah, and then for those that have multiple charges or multiple convictions in one county, you can consolidate all of those into one hearing, right? So even though we might have multiple petitions for all of those charges, if they're all in, let's say, Ramsey, you can have those all consolidated into just one Ramsey hearing to address all of the different convictions that your client is hoping to expunge. The only challenge is when it's different counties, then you're going to have different hearings in those counties. Okay, so there are criminal expungement clinics that exist around the state. Most of them are in the Twin Cities. So for those that are in Greater Minnesota, please do have those folks call us, because we can at least help out with some eligibility vetting, so they don't waste their time and their gas money driving into the Twin Cities only to be told this is never going to go away. So, but there are some really great services that are offered. Volunteer Lawyers Network, an agency that we partner with actually to do some work with victims, is really, really great. They've got expungement clinics at least once a month, depending on the county that you're talking about. So there are lots of opportunities to at least get that initial, yes, you're eligible, or you're not eligible yet, but if you stay clear of the justice system for the next 6 months, then at that point you become eligible. You can even start working on your criminal expungement petition now. Here's the documentation. I suggest you focus on this, right? There's a lot of things that go into this that folks can start working on, and just by having the knowledge that in a year they're going to be eligible, sometimes that can end up being hugely helpful to getting them focused and continuing on the right track and trying to steer clear of any potential other charges that might be coming their way. Making sure if your client is going to be attending a clinic, please do have them get those records ahead of time. It fully expedites the process, and it ensures that they're getting solid legal advice. If an attorney who's advising them doesn't have access to all of that information, that legal advice is not going to be all that helpful for them. So really working with them to get what they need ahead of time. And then those volunteer attorneys sometimes can be helpful in explaining what the service process is, filing those forms, and preparing for the hearing itself.
So some notes on safety planning as an advocate when you're, let's say the client is eligible, you've prepared all the documentation that you need, and you're ready to submit or to attend an expungement clinic. It's important to note that although the expungement clinics are held and hosted by really competent attorneys that really want to help, they might not always be considering domestic violence or sexual violence when they're looking at petitions, because from what we can understand, there's not a whole lot of expungement clinics, if at all, who are specifically working for domestic violence, sexual violence, or trafficking victims. So usually it's a criminal expungement that is more general for a lot of different types of cases. So as a DV or SV advocate, it's good to, if you can go and accompany the individual to be a support person for them. That's really helpful because a lot of the times there aren't social service agencies or advocates present at these expungement clinics, and sometimes that can be really intimidating and off-putting to your clients. So if you can go with them, definitely do, to make that process easier. And of course, collect and help prepare all the materials ahead of time. I put 2 weeks ahead of time. I only say that in case you need to get something from out of state, or if there's a processing time that needs to be taken into consideration. It's good to get all of those things up front. Obviously, this is going to be very it's going to be really stressful for the client. So it's really good in preparing coping skills and self-care and safety planning with these folks prior to the clinic, because they might not necessarily be prepared to talk about their abuse, but when they would be willing to talk about their criminal charges. Sometimes our victims will separate those two, and they'll be more willing to talk about one but not the other. So when you're talking,
really important. Sorry, Marie, go ahead.
Oh, that's okay. Yeah, when you're talking about criminal expungement that is directly tied to abuse, the folks at the criminal expungement are not going to be able to provide warning to that. They'll do their best, but it's important to know that the client does need to make those connections for the attorney in a way that makes sense to see whether or not they're eligible. And that can be really traumatic for people and hard and difficult.
Yeah, I mean, and the other thing to keep in mind here, and I'm sure this is not going to be news to any advocate that's on our webinar right now, attorneys do not get any education on trauma at all in law school. It is something that I think is a huge detriment to our profession, because honestly, almost every single attorney who is working with an individual client, that client has experienced some level of trauma, whether it's from an accident or they have their own, medical or mental health issues that they are dealing with, or in the context of our clients, the trauma and the abuse that they've suffered. And so there are very few attorneys that are going to be, especially volunteer attorneys, who want to help, but have likely just been through minimal training on this. And their day jobs might be sitting behind a desk and advising a company about something. That is very different than this kind of face-to-face discussion about very personal, very real abuse. And so, these attorneys are not typically going to be well-versed in this piece of the statute. They're typically not going to ask a lot of questions around, hey, is your criminal record connected to this abuse? And so to the extent you have a client who's going to be participating, helping them to know that they're going to need to just sometimes offer this information without even being prompted, because it's getting missed time and time again. Even in the agencies that do this work all the time, most of them will say, we've actually never had a victim get records expunged because it was related to their victimization. And I said, well, it's because you're not having the right conversations then. It's just getting missed.
Mm-hmm. Mm-hmm. It gets missed.
So yeah, there's a couple of other things on the advocacy end too that I think we just want to put out there for folks. And this is not something that advocates have to do for clients, but it is something to make clients aware of. So if you have a client who is successful in getting a criminal expungement, that is wonderful. You know, they're going to have to wait that 60-day period to allow any agencies who want to appeal. But after that happens, they then, you know, those records as it relates to the government side of things will be sealed. Now, that has nothing to do with what happens on the private side. There are, you know, private, basically like the companies that buy data from the government, private data collectors that sell that data then as background checks. And so those private companies, those websites are going to need to be informed that they need to take that information down because it is no longer valid. So it's going to look like the client calling them up and requesting that they remove it. You know, the Fair Credit Reporting Act has a whole lot of law and language around this. It doesn't typically require a whole lot of citation. Once there is an expungement order in place, just providing a copy of that expungement order to the agency should be enough to get it removed from that website. And so, you know, if your clients are becoming aware that their records are still out there, letting them know that they should be contacting those agencies or those organizations to have it taken down. For those that are unsuccessful in getting records expunged, you know, typically the judge, it doesn't always happen, but typically the judge will say why. Maybe it's because they don't believe enough rehabilitation has happened, or like I said earlier, maybe it's because they don't believe there's that strong of a need. Usually we advise folks to wait a year to 18 months to then apply again and try to really beef up either, you know, whatever the situation was that the judge felt was lacking, try to beef up that information. But they can try again. Just because they were unsuccessful the first time does not mean that they would be unsuccessful the next. Though we recognize that practically speaking, that's still a challenge. And if your client doesn't qualify for an IFP fee waiver, that can be an expensive process to have to go through again. So just something to keep in mind.
Mm-hmm.
And then Marae, as far as for those folks that don't ever qualify, what do you think?
If they don't qualify, point blank period, they've attempted and the court has told them that they could never get the charge expunged. As an advocate, we have to start looking at more creative resources. So we talked a lot about trauma and the way that exploitation is represented in our clients. So we're going to be looking at poor housing history. We're going to be looking at poor credit, inability to get sustainable employment. We have to be creative in our resources that we have. So obviously, if you are an advocate in Minnesota, you can recognize that the housing resources are few and far between / non-existent. I know,
What are
right?
you talking about? Yeah.
Weird. There's very little out there. So as far as finding housing for folks with criminal histories, looking at housing expungement, maybe not criminal expungement, but do they qualify for housing expungement? Since they're two different processes, maybe you'll have more success in that route. For credit building, there are microloans that are provided for sex trafficking, sex and domestic violence victims that you can start slowly building your credit. I know I got a notification from the National Domestic Violence Coalition, I think, NADVC. They're giving out $100 microloans for folks, for victims to start building that credit. So are there resources available for your client to start building back up that credit or getting payment plans? Or if they can go the civil route and not the criminal expungement route for the financial exploitation. As far as employment programs, are we looking at felon-friendly programming? Companies or organizations that do not consider criminal history as a deterrent for hiring people. There's a lot of restorative justice programs that are their main goal is to try and hire folks who have criminal records, and we are, at least in the metro area, getting more competent around accessibility for employment for folks who have criminal records. So as an advocate, we do need to be well aware of those resources. And we have some additional resources for you. Law Help MN has some really, really good, clear, plain language education materials that are very readable, so you could have your client read up on them. It has information on the process. Most of the things we've talked about today are also listed on Law Help MN. As far as Volunteer Lawyers Network, you can find upcoming criminal expungement clinics that are being held throughout the state, mostly in the metro area, right?
And VLN does also have some capacity to do direct representation with particularly challenging cases. You know, they do have volunteers that will do that direct representation pro bono. It's rare. It's hard to get it. Obviously, you have to also qualify in terms of their income requirements, but at least as it relates to the expungement clinics, that is a far more accessible way of at least getting that immediate advice from them on how to structure a petition and what to say and what not to say. The other thing I want to note too, in the Law Help MN as well as the Minnesota courts, they've done a lot of work to try to get information out to folks about criminal expungement. The Minnesota courts link that you've included here, Murray, it actually has videos too that'll walk you through section by section of the petition and how to fill it out, which can be super helpful generally. Not any of these are geared towards victims of crime, and there is no mention made about that nexus between the crime that was charged and convicted, and then ultimately that status as a crime victim. So, you know, just things to point out to your clients if you're going to share these resources is they're not going to be prompted to include that kind of information in their petition, but if they want to, they can and they should. And then so up top, this website, our website here, we have a lot of different resources already on our website for folks who've experienced domestic sexual violence trafficking. But soon, hopefully within the next month or two, we will also have a packet on there that actually does talk about that nexus between victimization and the crime and how to fill out a packet. So stay tuned for that, because I think that'll end up being a really helpful resource for folks. And that's us.
Yay.
Yeah.
Hey. Wow, we did really well.
Timing wise. There we go. Questions from folks. I know we ran through a lot of different information, and we also didn't actually go too heavy into what qualifies and what doesn't purposely. So if people have questions, please do feel free to chime in, type it in right here in the chat box.
There is a question. One question, do you guys have any information for those seeking to expunge federal charges or convictions?
Let me think. I mean, I'm sure Volunteer Lawyers Network has had to do this sort of work before. I think that would be my first stop, is suggesting somebody call them, because I have no idea what federal law allows for and what it doesn't. Those crimes are oftentimes very different, and to be honest, maybe there's something in the Violence Against Women Act and I just don't know it. So that would be my suggestion, is first stop, call VLN, just simply because they do these regularly and see folks with both state and federal level crimes. But that's the best I can do right now. Murray, you have anything else? I know. Sorry, Melinda. That's a totally fair question. It's just one that we haven't had to deal with, because it's honestly, most criminal activity is prosecuted on a state level based on state law. So that is why that comes up so much more often.
Yeah.
Anything else from folks?
No.
Okay.
Thank you.
Yeah, we're here. Give us a call. That's why we exist. We love to hear from you all and from your clients. So keep doing the good work that you all are doing. We know this isn't easy.
Right. I'm going to end the webinar now. Thanks, everyone.
Happy
Gracias.
Halloween.